We're gonna get started here. Thanks so much for joining, everybody. So, this is our presentation, and it's for the purpose is really to give a high level overview of some advanced patent law topics, and it's really meant for patent stakeholders and for attorneys that may dabble in business law and are exposed to patent law. It's really for some high level topics on some more advanced topics, advanced patent law topics. Some quick housekeeping issues. If you have any questions, you can message it in the chat, ask it in the chat, or you can raise your hand. Jesus, who's my colleague, he'll be monitoring, and he'll kind of reach out to me. If we can answer them, we'll try to answer them as we go along. If there's a lot of questions, I don't anticipate many questions as we go along, but we can always answer them at the end if there are any unanswered questions. With that said, we're going to get started here. So just a bit about me. I have a background in engineering. I was an industrial engineer and a mathematics major. I was a senior field engineer for a company called Schlumberger. It's an oil and gas company. I worked overseas for a few years. Then I worked as an engineering project manager, designing electrical infrastructure at Florida Power and Light. Went to University of Florida for law school and became a patent attorney. And I'm licensed practice in New York, DC, and Florida. So before we get started and really dive into some of the more complex topics, I wanted to just briefly go over some basics so that we're all on the same page. The term prior art really is any evidence that your invention is already known. Okay, so what that means is it has to be publicly available. And it actually does not need to be physically available or commercially available. It just needs to be existing and publicly known and published before the filing date of the invention. In fact, the federal court recently ruled that they had a ruling that an operations manual that did not have any confidentiality provisions, that was for an internal operation manual, that actually would be considered prior art. So be careful with what you disclose. So the entire world operates under what's called the first to file system. What does that mean? That means the right to grant a patent will be given to the person who files the application first. Okay, the entire world operates under that premise. Now, before 2013, March 15th, 2013, the world and the US actually operated on a first to invent system. That means that if you could prove that you were the inventor, you could actually invalidate a patent and also acquire a patent before the filing, before 2013. So if you could prove that you were the inventor over an application was filed first, you actually could get the rights to it. But in 2013, the American Invents Act was passed by Obama, and now we operate like everybody else under what's known as a first to file system. So challenging a competitor's patent, we get that question sometimes, and there are several ways to challenge a competitor's patent. The first way that you can challenge a competitor's patent, and definitely the least costly way to do it, is actually before the patent actually is granted. So if you see a patent filed, a patent application that's filed, and you realize that you actually may be able to, it's a competitor, and you actually realize you're selling a product that's covered by this particular application, you can actually submit information or submissions to the patent office, and the patent office will actually review those submissions, and they may decide not to grant the patent based upon your submission. But you must file the submission before the patent issues. So what does that mean? You actually have to file documents, and you have to file within a certain period of time. It has to be done before what's called a notice of allowance, or the earlier of an office action rejecting the application on the merits, or the date it's published. So if you see that it's published, you see something that could be an issue, don't wait. File the submission as soon as possible. After a patent is granted, you can also challenge a competitor's patent. There are several ways to do it, and these are known as the post-grant proceedings. Certainly, the most broadest scope you can actually, most broadest post-grant proceeding is known as the PGR. It's a post-grant review. Anyone can initiate a post-grant review, and it's actually filed with the Patent Trial and Appeal Board, the PTAB. You're going to hear that acronym a lot. Patent Trial and Patent Trial and Appeal Board, PTAB. Must be filed with the PTAB, and it's actually a trial between two parties, the patent holder and the person that's submitting the documents. And essentially, you can raise issues, any issue that that can challenge the grounds of validity, whether it's a 102 issue. That means that a single reference anticipates or teaches all elements of your invention. A 103 issue, it's 35 USC 103, which basically says that two prior art references combined teach all elements of your invention. Or you can also submit 101 issues, patentable subject matter issues, 112 issues, which are indefinite issues, or whether or not your application properly disclose your patent specification properly discloses all elements claimed. Okay, so PGR, broadest scope of way to challenge a patent. One thing to note is that it must be filed within 9 months of the patent and the issues, and it sort of makes sense. It gives you the broadest means to cancel a patent as the earliest after it's being granted. So within 9 months, you can initiate this post-grant proceeding. The next way you can also challenge a patent is through reexamination. And that's an ex parte action, and it's filed with the USPTO, and it's actually dealt with at the reexamination unit at the USPTO, the United States Patent and Trademark Office. And anyone can request a reexamination at any time during the life of a patent. It's helpful because it can be anonymous, so you could hire an attorney, and the attorney can submit the documentation. And if it's instituted, more than likely, the patent owner would not know whether who really instituted the proceeding, or what person or entity actually instituted the proceeding. What's interesting to think about is, or how the reexamination works is, you actually have to submit documents, and you have to prove with the petition it's a substantial new question of patentability, whether it's prior art references, or a 102 reference or a 103 reference. And it's actually, as far as a post-grant proceedings go, it's actually the least costly way to challenge a patent. It's about, as far as filing fees go, it's about $2,500 to file a reexamination. It can be more expensive, $2,500 for a non-streamlined reexamination. That's about $40. There's two different types of reexaminations. One is a streamlined and one is a non-streamlined. The streamlined is less than 40 pages. Non-streamlined is more than 40 pages. So you can file the reexamination at any point during the life of the patent. And really, you can only deal with 102 and 103 issues. The next proceeding is the IPR. The IPR can be filed at any point, can only be filed after 9 months of the patent being issued. So after 9 months, you file an IPR, but the IPR, inter-party review, must be filed within 1 year of a lawsuit being filed. So if you were served with a lawsuit, you can move to invalidate the patent in an IPR, but it must be done within 1 year of the civil action being initiated. Any third party can initiate it, and again, it's actually an inter-party review, so it's between the two parties, and it's a trial at the PTAB level, the Patent Trial and Appeal Board. The cost for a IPR, the filing fees alone are about $42,000. It's more costly because it is a trial. So now I will tell you that for IPRs, according to the AIPLA, the American Intellectual Property Organization, the AIPLA states that it's less costly to actually litigate at the PTAB level with an IPR than it will be to go into federal court. So many times, even though the cost is more costly up front, in the long run, it's actually less costly to do an IPR. The last one we're going to, well, the second to last one is the covered business method review. That is for issues for 101, 102, and 103 issues. The person who can initiate an CBM, a covered business method, must be charged with infringement. So you actually need to be litigating the issue. And a CBM is actually for non-technical related matter. So financial business methods, things of that nature. It can't be a technical in nature like a software patent. That's not how CBMs work. A derivation proceeding, that's really used if you are trying to challenge who invented the invention. So for example, if you invented an invention and somebody gets that information from you and that person files a patent and gets a patent, you can challenge that second person that got the information from you that got the patent in a derivation proceeding. And you have to have substantial evidence that it was derived from you. So you have to have substantial evidence that that person obtained the information from you that acquired the patent. Before I move on to protecting your invention, essentially for challenging a competitor's patent, what's really important to note is that how you have the opportunity to challenge a patent through the life of the patent, through the term of the patent. So if it's an issue, think about challenging the patent because it may actually be less costly than litigating in federal court. Protecting your invention. What I really want to point out here is the dangers of early disclosure. They are different grace periods. In the US, we have a 1-year grace period. A grace period basically means that if you disclose your invention, you have 1 year after you publicly disclose your invention to file an application in the US to acquire a patent in the US. So, for example, you disclose on Facebook or you say how amazing your invention is at a conference. You disclose that information, you still have time to file the application for up to 1 year. However, be careful. Other jurisdictions don't have a year grace period. For example, the UK has a 6-month grace period. China has a 6-month grace period. So if you're going to be disclosing at a conference or a seminar, be very cautious because some countries don't have a grace period at all. So we think it's important to make sure you have the right strategy and plan. Make sure you have your NDA signed by your employees, independent contractors, or people that are evaluating the concept. And also, quite frankly, you need to think about filing an application early. International patent protection. Again, we're going to just briefly talk about this, but a PCT application is a patent cooperation treaty application. It allows you to seek patent protection in numerous countries. A single application can help you cover up to 157 countries. How this works is if you file an application, if you file an application in the US, you must file a PCT application within 1 year of filing in the US. So if you file a provisional or non-provisional patent application in the US, you need to be thinking about whether or not you'll be filing internationally early on in the process, because that 1 year, the deadline to file the international PCT application will come quick. After you file the PCT application, you have 19 months to decide which jurisdictions you're going to go into. So think about international protection. You may or may not want to pursue it depending on where you are in the process, but that's something you have to think about early in the process. And I strongly encourage you to counsel your patent stakeholders and your colleagues to consider that early on in the process because it makes a difference. Provisional patent applications. Again, securing early patent rights. A few things about the provisional patent applications are, one, it's cost effective. It allows you to establish that early filing date. Very important. Again, we talked about that grace period and then also the different grace periods. If you file a provisional patent application, it allows you to establish the early grace periods, or excuse me, the early application filing date. Generally, it's less costly. The attorney time it takes to draft is much less. The formal requirements are much less than in non-provisional patent applications. And also the inventor The inventorship requirements are much less. What do I mean by the inventorship requirements? Well, in the United States, you do not need the inventor to sign the inventorship documents for a provisional application. It's a good practice to do that, but if you have a dispute over who is the inventor, or if maybe one inventor is not available, maybe you have a disgruntled employee that's refusing to sign documents and you don't have time to get those documents, you can still file the provisional patent application or a patent application to secure that early filing date early and deal with those inventorship issues at a later time. Very important. Sometimes it becomes a big issue in larger companies where people move between departments and different R&D departments. So that's something to think about. The second thing that a provisional patent application provides is that how it actually provides the patent pending status. It's great to try to test the commercial viability of the product. You can raise the capital, you can make design improvements, you can change things, and it also gives you the right to file the non-provisional or seek international protection in the future if needed. Very interesting and also very helpful. Expediting patent applications. This is a really big challenge right now, and I think it's the value for expediting patent applications is critical, especially when you're dealing with international protection. Right now, I just checked this a couple of days ago. The backlog is about 770 unexamined applications. The current wait time is 20.2 months to wait to be examined. It can be less, but according to the USPTO patent dashboard that's put out by the USPTO, 20.2 months is how long you're going to wait to get an application examined. So what does that mean? That means that if you file an application now, you're actually not going to know whether your invention's patentable until after the international filing deadline is passed. So we recommend fast tracking or expediting patent applications in certain cases. There are several ways to do that. You can do what's called track 1 for utility applications. You can do an accelerated program for design patent applications. There's also a petition to make special because of age. If you have one inventor that's over 65 years of age, you can actually fast track the application and actually for free, you can actually do it for free to expedite the examination process to get the patent granted or examined faster. It goes, typically right now, depending on the art unit, you actually can have the patent application examined much faster. Generally speaking, it's about 4 to 5 months. We recently had one examined within like 2 months. We filed the application in late December, and we're already received an office action or responded to it already. So depending on the art unit, it can greatly reduce it. And what's great is that how you're going to know whether or not the patent application is going to be granted hopefully long before the international filing deadline, which is a big strategic advantage. So strongly recommend considering expediting the patent applications. Non-publication requests. This is another way you can create a competitive advantage. I like using it when you're not sure if your invention is patentable and you want to potentially create a barrier, a competitive advantage. One way you can use a non-publication request is by preventing people from actually seeing your application online. So let me back up. After a patent application is filed, 18 months after the patent application is filed, it's automatically published. That means that 18 months after you file your application, everybody's going to know what's in that application. If you file a non-publication request, you must file it at the beginning of the process, on the day of the application. And after you file the non-publication request, your application will not be published. It's a great way to potentially have trade secret protection. It allows you to maintain your information confidential because really it's not going to be published, and very limited people will know the information that's in the actual application. So you can actually file the non-publication request, go through the entire patent application process, If it does not get granted, you still have the opportunity to keep it as a trade secret. Really important, great way to potentially have patent protection. If you can't get it, go after trade secret protection in the future. One caveat is non-publication requests. You must, the inventor and the applicant must actually sign a declaration that they do not seek international protection outside of the United States. So if you're going to be going outside the United States, this is not available for you. The ITC, the International Trade Commission, this is an alternate venue for IP disputes. There are several benefits and disadvantages for litigating at the ITC. One of the biggest advantages for litigating at the ITC is it offers a much faster process of getting exclusion and cease and desist orders. Okay, so what's a cease and desist order? Well, a cease and desist order, after you go through the patent infringement process or patent litigation at the ITC, if you're able to prove that it's infringing, if the device is infringing, you can get a cease and desist order, and the commissioner will forward the cease and desist order to Customs and Border Protection, and the Customs and Border Protection, the cease and desist order is actually forwarded to the respondent of the ITC complaint, and the respondent is going to be required to actually respond by giving certain information to the commissioner. And what does that mean? They're going to have to tell information about how many goods they have in inventory, where it's been shipped, the value of, and they are no longer allowed to actually ship in the United States or sell within the United States. Every day that the respondent does not respond to the cease and desist order or provides any false information, it allows for fines for up to $100,000 per day or twice the value of the infringing articles. And that is a huge advantage for businesses that are dealing with legitimate businesses in the United States that are going to be violating cease and desist orders. Now, let's talk about some of the disadvantages. Well, first off, two more advantages. The ITC has a lot of expertise in complex IP cases. And like I just mentioned, it's much faster than in litigating in federal court. And you get these orders, the cease and desist orders and exclusion orders, much faster than going to the federal court. The disadvantage is you're not going to be able to actually get monetary damages from the ITC. You actually, would need to go. The respondent would have to violate a cease and desist order, and you'd have to go and enforce that cease and desist order and the violation in the district court because of the violation. So that's something to think about. You're not going to be able to get monetary damages, so to speak. You're just going to get people to stop selling. Also, litigating the ITC, it takes a lot more much more resources. Why? They have a lot of rules that require paper documents. For example, you have to file, I think, 12 copies of a complaint. They have all these different rules that require much more resources for a person to actually litigate. So that's something to think about as well, is it's probably going to be more costly in the short term. One more thing, the exclusion orders. What's an exclusion order? It's the order. If you are successful at the ITC, you can get an exclusion order, and that exclusion order is actually sent to Customs and Border Protection, and that Customs and Border Protection will actually deny articles from being imported into the United States. So that's something that's very helpful for the ITC as well. The Amazon Apex program. This is one of the somewhat new programs that Amazon has put out. Essentially addresses utility patent infringement. It's not available for design patent infringement. So essentially, Amazon Apex program stands for Amazon Patent Evaluation Express Program. And it's, again, only dealing with utility patent infringement. And it's a great way to deal with patent infringement on Amazon. You're actually allowed to basically try to take down up to 20 ASIN numbers. And ASIN stands for Amazon Seller Identification Number. So if you have a patent, you can actually, if there's, there's 20 listings that are being sold on Amazon, you can actually take down 20 listings at the same time using the Amazon Apex program. Procedure is this. If you're a patent holder, you have to file a complaint with Amazon about the accused sellers. The accused sellers are notified. If the sellers do not respond, then the listings are automatically taken down. If the seller responds and says, yes, I'd like to respond to this complaint, I think I'm not infringing, then both parties actually put up $4,000 each, a neutral arbitrator selected by Amazon. And then after that happens, the patent holder will actually submit a brief stating why each of the ASIN numbers or each of the products are infringing on the particular patent. After that's submitted, 14 days afterwards, each of the sellers must respond with the reasons why they're not infringing. 7 days after that, the patent holder can then file another reply. After the reply is submitted, 14 days, the arbitrator or the third-party attorney will actually announce his or her decision. So you're talking within 3 months, you can actually have, potentially hundreds of products are being sold, taken down from Amazon. It's a great way to deal with infringement on Amazon. But again, before you do that, you need to make sure that you actually have legitimate claims, because false and incorrect claims can actually cause an issue for you. Why? There's a potential that there could be considered some tortious interference claims. If the seller fails to respond, the accused seller fails to respond, and Amazon takes its listings down, then potentially, if your claims are bogus, that accused seller could potentially go to federal court and make a claim for tortious interference between that accused seller, falsely accused seller, and Amazon. Now, there have been one more thing is decisions are final with no appeals from Amazon. And then if you're not successful, you can actually appeal to federal court and get and move forward that way as well. But really interesting program. We've actually been a part of it before, and it works. This one is about ownership of intellectual property rights. So first off, let's start with the basics. An inventor, if there's multiple inventors or a single inventor, the inventor is actually owns the rights to the patent, owns the patent rights to an invention, unless a document stating otherwise is signed. So that means that even if you have an employee or independent contractor, unless they sign an agreement transferring the rights to you, that independent contractor employee actually owns the rights. So assignment agreements and transfer agreements are critical. If you are representing a client and they are working with a patent attorney, make sure that you know who the owner is. Make sure the patent attorney knows who the owner is. Before the application is filed, make sure you are clear who the owner is, that the proper documents have been signed. In your employee handbooks and your employee agreements, make sure that you have future assurance provisions and cooperation provisions that say that how you're going to agree to sign additional documents in the future if needed. And why is that important? If you have a disgruntled employee or an ex-employee and they're no longer available, if you have these future assurances provision, it's going to be a lot easier for a general counsel to go to that employee and say to them, listen, you signed this document and you have to sign these additional documents that we need to pursue protection. Now, why is that important? And if you're filing internationally, there may be several countries that you're going into, and each of those countries require additional documents to be filed that are signed by the actual inventors. So just one document may not be enough. There are procedures for handling, employees that are not available, but it's always great to have that kind of locked up so that how you have a future assurances that they're going to cooperate in the future. Inventorship and patent laws. So we're coming to the end of our conversation here, but this is kind of AI related. It's a super hot topic. So who is going to be on the inventor? Who is going to be the inventor in an application? This is always a question that we get. One of the things that we are always taught is that an inventor is someone who contributes to the conception of the invention. That's really important. You can't just reduce the invention to practice. You actually have to come up or conceive the invention. So if you are hiring a third party if you have a concept, your client has a concept, and they're just really using a builder to actually, put the concept down and to make it work, it depends on what exactly that builder does and what they come up with. They may not be considered an inventor. However, I will caution you, if you're hiring third parties to develop different things, I highly recommend that you make sure upfront that those builders agree to sign all the rights to your business or to your client. I think it's super important to make sure that that's done. Now, who can be an inventor? Actually, the Federal Circuit has ruled on this. Only a natural person can be an inventor. Okay, only a natural person. So you cannot be a robot and be an inventor. You have to be a natural person. So what does that mean in the AI context? Okay, so the USPTO recently put out guidance about the implications of AI related inventions. And essentially, if an invention is created by AI and it's solely created by AI, it's not going to be patentable. The reason why is, in short, the USPTO guidelines said that how they would actually, an inventor would actually to produce, the inventor must be a natural person, and that natural person must make a significant contribution to the invention. So if a person uses the uses AI to create some sort of invention, that's okay. But they cannot, the human, the person who is creating the conceiving the invention, must be a significant contribution. So if you're only relying on AI to create different things, that's not going to be patentable. A person must contribute significantly or must have a significant contribution. The guidance that they specifically put out also talked about the Panu factors. That's a test that was put out by the Federal Circuit. But essentially, the natural person must have made a significant contribution. And that is a really hot topic right now. So that's something to think about, and it's going to be litigated heavily in the future. But that's it. So with that said, any questions? And the course, I'll put this in the chat here. This is the course number for those who are looking for CLE credits. Let me give you, I'll put this in the chat. This is the CLE number. So you can apply for your CLE credit on the Florida bar. That should give you your CLE credit. And I'll hang on if you guys have any questions. Yeah, that's it. If you have any questions, let me know. Enjoy the CLE credit. And thanks for joining. I really appreciate it. And if you have any questions, just reach out to us. Happy to help. Have a great day, everybody. Ben.